Get ready for the dictation. Start. This court has considered the order impugned dated 16/11/2019, which mentions the facts of the tenant filing the application paper number C44 and also the objections filed by the landlord to such amendment application. The court had perused this court's earlier order dated 11/12/2013 and has mentioned the same also in the order and thereafter rejected the same on grounds that it had been moved with extreme delay at the time when evidence had been led by both the parties and their case had been fixed for arguments. Also, it has been observed by the trial court that whatever the tenant wished to bring on record by means of the proposed amendment was already there as mention of the judgment and order dated 11/12/2013 had been made by the petitioner in his written statement itself. The facts as mentioned in the High Court's order could not be denied by him. This court finds no good ground to show interference in such an order, which has considered all the facts as also the papers available in the file. Insofar as the first judgment cited by learned counsel for the petitioner is concerned, this court has gone through the judgment rendered in Sajjan Kumar versus Ram Krishan, where the proposed amendment were with respect to the correct description of the suit property in the plaint, and therefore the Supreme Court had observed that such amendment should be permitted even though filed with delay as non-amendment of the pleading and failure to describe the suit property in question correctly would create needless complication at the stage of execution in the event of success of plaintiff in the suit. The second judgment relied upon by the learned counsel for the petitioner is Usha Devi versus Rizwan Ahmad and others, wherein the Supreme Court was considering the amendment petition having been filed after framing of issues and observed that proviso to Order 6 Rule 17, which bars delayed amendment of pleadings, is referable to the stage after commencement of trial. In this case, also there was error in describing the property in plaint schedule. The defendants filed the written statement raising the question of wrong description. No rejoinder was filed to the written statement by the plaintiff. Issues were framed on the basis of pleadings. The proceedings in the suit lingered, and the plaintiff filed a miscellaneous application alleging breach of interim injunction. An amendment application was later on filed by the plaintiffs stating that due to inadvertence the said land was wrongly described in the plaint schedule and the mistake is liable to be corrected. The amendment application was rejected by the learned trial court, giving finding of lack of due diligence. The Supreme Court held that in view of the error of description of property in plaint, the defendant had to suffer injunction against their own property. In such a case, ends of justice would be met by allowing the proposed amendment subject to payment of cost by the plaintiff. In Ramesh Kumar Agrawal versus Rajmala Exports Private Limited 2012 5 SCC 337, a suit was filed for a specific performance of agreement for sale of immovable property, pleading that the entire consideration under the agreement had been paid. The amendment application was filed immediately after filing of the suit and before commencement of trial, seeking to explain how and in what manner such payment of consideration was made by the plaintiff, giving details of the payments. The court observed that the proposed amendment would not alter the cause of action, nor it would cause any inconsistency in the case of the plaintiff or prejudice the appellant/defendant. Stop.